18.3.105, criminally negligent homicide. 18.3.105, criminally negligent homicide. Any person who causes the death of another person by conduct amounted to criminal negligence commits criminally negligent homicide, which is a Class 5 felony. So don't do that shit. Don't come to Colorado thinking you're going to commit negligent homicide, nor first or second degree murder, nor vehicular murder, nor manslaughter. At the very least. Can we all agree on that? I don't give a shit if you agree with it or not. It's the fucking law, you piles of shit. So if you don't have any morals, you better obey the law. You come to Colorado, you obey the law of Colorado. No first degree, second degree murder, no vehicular manslaughter, no criminally negligent murder, nor manslaughter. Here's some annotations. Classification of first degree assault as more serious than negligent homicide constitutional. People v. Lucero. To be found guilty of criminally negligent homicide, the defendant must fail to perceive a substantial and unjustifiable risk that a certain result will occur, and the risk must be of such a nature that the defendant's failure to perceive it constitutes a gross deviation from a reasonable person's standard of care. People v. Jones, 1977. The defendant's guilt in criminally negligent homicide stems from his culpable failure to perceive the risk. People v. Jones, 1977. Criminally negligent homicide is an unintentional killing caused by the actor's failure to perceive a substantial and unjustifiable risk that a certain result will occur. People v. Hernandez, 1980. Criminal negligence as applied to homicide means a failure to perceive, through a gross deviation from the standard of reasonable care, a substantial and unjustifiable risk that death will result from certain conduct. People v. Taggart, 1981. People v. Shaw, 1982. Attempted criminally negligent homicide, logical and legal impossibility. Where the trial court joined criminally negligent homicide and attempt and charged the jury on attempted criminally negligent homicide, the charge was logical and legal impossibility. People v. Hernandez, 1980. Defendant cannot avoid his conviction on the ground that he did not intend death to result from his act. People v. Palumbo, 1976. In this section, in 18.3.106, there's a crucial difference in that the vehicular homicide statute requires for conviction that the prosecution prove the additional element of a death caused through the use of a motor vehicle. People v. Halsey, 1976. More severe penalty for vehicular homicide does not deny equal protection. It cannot be said that the legislature's decision to provide a more severe penalty for vehicular homicide than for criminal negligent homicide is arbitrary or unreasonable. The state has a legitimate interest in discouraging a specific evil which it believes to be of greater societal consequence. This choice does not offend equal protection. People v. Hall, say 1976. Classification of child abuse as more serious than negligent homicide constitutional. The legislative classification of child abuse as a crime more serious in penalty than the offense of criminally negligent homicide is neither arbitrary nor unreasonable and does not violate equal protection of the laws. People v. Taggart, 1981. Reckless manslaughter and criminally negligent homicide distinguished, 1982. The actions of a defendant convicted under this section may be the same as a person convicted of 42.4.1402. 2. Careless driving resulting in death, 42.4.1402. The enactment by the General Assembly of a specific criminal statute does not preclude prosecution under a general criminal statute unless the legislative intent to limit prosecution to the specific statute is shown. Here, no such intent is found. People v. Toe, Colorado Appeals, 1999. Elements supported by credible evidence. People v. Palumbo, 1976. Conviction as barred to prosecution for assault on another. Conviction of former crime of involuntary manslaughter for fatally wounding one person while shooting at another bars a prosecution upon a charge of assault to kill and murder the person at whom defendant shot. Carson v. People, 1894. 1894. Carson v. People. Conviction as barred to prosecution for assault on another. A conviction of former crime of involuntary manslaughter for fatally wounding one person while shooting at another bars a prosecution upon a charge of assault to kill and murder the person at whom defendant shot. Carson v. People. 1894. Coming up next, vehicular homicide. Don't do that either.